India's IT minister has submitted a new data protection bill in the lower house, that is the Lok Sabha. The new bill is called Personal Digital Data Protection Bill. So what is it all about? I am Devishi Sarkar and you are watching News 18. Now the new Digital Personal Data Protection Bill is simply an updated version of the privacy bill that was introduced last year. But it scared a lot of tech giants including Google, Microsoft, Facebook, Meta and others. But suddenly the government took it back without providing much of an explanation. But what is this new bill all about? I'll try to make it very simple for you to understand. And is the new data protection bill as powerful as compared to the European GDPR and the American Consumer Privacy Act? Let's find out. Now, before I start, I'd like to clarify that this is still a bill. It's not a law yet. The new Digital Personal Data Privacy Bill gives massive powers to the central government. Number one, it is a central government that is responsible for establishing the Privacy Board, the Digital Data Privacy Board and its members and chairperson. Number two, the central government, including the board and its member and chairperson, have got legal protection. That means legally they are not accountable to anyone. Next is the government will also have the power to waive off this law entirely in certain circumstances for certain companies, including startups. That means this law may not be applicable sometimes as well while it is enforced every other time. Lastly, another most important thing is that it is the government that will decide where the personal data of Indian users can be taken, to which country it can be taken outside India. That means if the government issues a list of prohibited countries, then the companies cannot be able to take personal data of Indian users to those countries. And if they by chance have servers in those countries, they will have to relocate somewhere else for Indian users. Now, talking about board members, it is the central government that will decide who gets to be a part of this entire digital data privacy board, and the members will initially have a term of 2 years. They can only resign after providing proper notice to the government, and once the notice is accepted by the government, they have a formal notice period of 3 months or a suitable replacement is found. Now, talking about consent, there are certain exemptions as well. We are still not clear on what are those exemptions, but yes, there are certain exemptions that the government may apply. Now, if you're using public services like websites of Aadhaar or any other public services to fill out online forms for government services, whatever data you voluntarily provide can obviously be accessed. But the same data can be accessed by the government as well if they want to. Another important aspect of this bill is that for individuals, like for people like you and me, it is absolutely important that you provide your original personal information, genuine personal information. If you are caught impersonating others, or if you are providing fake data about yourself on, say, government services website or any other platform, then you will be penalized if you are caught. So that is a new mandate that is there in the bill. Next, talking about data localization and data retention. Now, the government has relaxed data localization norms. Localization means that what data needs to stay in India and what data can be taken outside India by big tech companies. But at the same time, there are certain clauses as to where companies may not be allowed to take the personal data of Indian users outside the country. Now, those countries, there will be a list of countries that the government may keep on changing and editing as and when situation arises. Another aspect is that, talking about data retention, this bill highlights a very interesting thing. That is, your personal data, once you have provided consent, while you can take back the consent that is there, the data retention has no fixed limited period. Even if the business of taking your data in the first place is over, the data can be retained for how long anybody wants to. Like any big tech companies or any government services website that you're using, you're providing a personal data. There is no fixed time period or expiry date of the data. That data can be retained for as long time as they want. Now, the bill has also made a provision that decisions made by the Data Protection Board can be appealed to the Telecoms Dispute Settlement Division within 60 days for another review. So these were the key elements of the new Digital Personal Data Protection Bill. But let's talk about how powerful is it compared to the European GDPR or America's Consumer Privacy Act. Well, when it comes to powerful act or not, we have to decide on the fines. What happens when somebody or some company doesn't follow the law, and of course they will be fined. What are the fines? For an individual, it is just rupees 10,000. So if an individual provides wrong data or is impersonating somebody or is breaching somebody's digital privacy, then the fine is rupees 10,000. And if a company does the same, if they're not following and abiding by the law, the fine is rupees 250 crores. Now rupees 250 crores for a company like Google, Amazon, Microsoft, Meta may not be that much. These 250 crores for companies of this scale may not be a lot. For startups, of course, it's a huge amount. But then again, it is still not clear as to how the government will exactly enact this law and how. Because if you're saying that there are provisions to waive off certain laws for during certain times, things may get a bit challenging for the board as to decide when it's the right time to fine somebody and when it's not the right time to fine somebody. But like I said, this is just the bill. It is not yet a law yet, and there may be another version, that may be updated version that is coming up later. We still don't know, but this is what has been announced right now. This is Devashi Sarkar for News 18.